This is the current federal tax developments for the week of March the 16th, 2026. Current federal tax developments are brought to you by your state society of CPAs. Well, we're going to kind of look at what went on this week. For those of us who've been in tax trenches for decades, we know that these new statutory regimes, whenever they come up, mean a wave of technical compliance work and planning opportunities for those of us in the business. Today, we're going to dissect the newly proposed regulations for the Section 530 Cap A Trump accounts. Remember, they're debuting on July 4th. We're also going to look at the companion pilot program, which also got proposed regs this week. A critical final ruling on micro-captive disclosures, which is where we went back to court after the IRS, after losing in court on the use of notices to add items to the listed transaction list, came back out with a regulation under this, and we now have the court, as you might expect from the company that won on the first challenge, is going back to court now and attacking the regulations, and we'll see how that went for them. We've got a Bipartisan Budget Act audit notice case. It's a published tax court case that reminds us why procedural details and statute of limitation issues are paramount and what the court allowed in this case. So let's start looking at this week at what's going on. So again, I'm going to talk about the two sets of proposed regs. So you see them up there if you're looking at the slides for the Trump accounts. So we have both the basic proposed regulations and then the regulations under Section 6434, the Trump account pilot program, the $1,000 deposit for children born in 2025 through 2028 into a government-funded Trump account. We're also going to be looking at, basically looking at the IRS micro-captive rules, as I said. In this case, Tennessee District Court formally upheld the IRS's scrutiny and objective reporting factors in the regulations that essentially just duplicated the notice they'd published previously. The court was saying, the previous problems have been corrected in this point, because that was mainly how they went through the process of adopting the rules in question. And having now fixed the process, the fact that the result ends up being awfully close doesn't really change anything. And finally, we're going to wrap up with the Mammoth Cave Property LLC BBA audit case, which is an issue where we have an IRS notice that has defects, but how that interacts with the statute of limitations, and especially with the equivalent of what becomes, in this case, a no harm, no foul issue. That is, even though the notice was addressed to the wrong address, the fact is the taxpayers' actions proved, in this case the partnerships, that they had received the notice. That became a no harm, no foul situation. And for that reason, the partnership still got a problem with the notices they've received from the IRS. So we're going to kind of take a look at this, hopefully a little more practical here, and looking for action items you might want to have coming up here shortly. So let's go ahead and take a look. This is the proposed regulations for Section 530 Cap A Trump accounts. You're going to find these in Regulation 117270-25, it's proposed reg. The proposed reg was issued on March the 6th of 2026, and it deals with the Internal Revenue Code Section 530A, the Trump accounts, added by the One Big Beautiful Bill Act. Right? And so what we're looking at here are basically the foundational rules and definitions for creating these accounts. They're very much in line with the notice we got a couple of months ago, right? We aren't going to understand, though, the structural constraints right now, because right now clients are setting up, and asking the government to effectively set up for them Trump accounts for their children. There have been reported by the government at least over 1 million such accounts. Already they have the information to set those accounts up, which presumably will pop into existence on July 4th of this year. So we need to understand how it works. We have to deal with it right now. Even though it's tax season, you're going to deal with it. And you find that clients love the idea of free money. So it's one of those things where there's going to be some pressure. And remember, there is no qualification level for the $1,000 pilot program. It's not like above a certain income, if the child parent is above a certain income level, they don't get the $1,000 everybody gets 1,000. So that makes this one a little different. Okay, so let's talk about the structure and classification of Trump accounts themselves, right? Technically speaking, a Trump account is treated as a specialized traditional IRA under 408a, right? It's established for the exclusive benefit of what's called an eligible individual. Now, the proposed regulations propose to put strict guardrails in place. They expressly prohibit establishing these as simple IRAs or receiving SEP contributions under 408k. In fact, you have to receive your contributions under the rules specified for the Trump accounts themselves. They work like an IRA. Once the child hits 18, they arguably effectively become an IRA, but in the interim, they're not an IRA. So you have to keep that in mind. For average firm clients that are small business owners, you got to make sure that we're going to talking about not accidentally commingling these different types of kind of IRA accounts, right? We have all kinds of IRA accounts now. The traditional, we have the simple IRA account that may be important for the first couple of years of the program, first couple of years participation by the employee. We also have the concept of funding via a SEP. And now we've got this new type of IRA. Well, I should say we also have the Roths, which are a different type of IRA, just like this, and 530 Cap A, which is an account that's not technically an IRA until the kid turns 18, and that gets a little messy. But it works like one, but like one doesn't mean it is one, right? And the Treasury has also indicated in the proposed regs that they're going to bifurcate these accounts into what are called initial and rollover accounts. There is a strict limit that a taxpayer can only maintain one funded Trump account at a time for an eligible individual. An eligible individual has one and only one Trump account. You can't have everybody establish one. We're going to have one account, and if you want to move the account from the current custodian to another, you got to move the whole thing, and the account with the old custodian will disappear. That's basically how it's going to work. And also, you cannot retroactively amend the existing traditional IRA to convert it to a Trump account. The governing instrument has to be correct from inception. So if you accidentally set up an IRA and you put the Trump money in there for your own, not the pilot, but your regular contribution, yeah, you can't just get that changed. You're going to have to go back and remove it from the traditional IRA because you know what, your infant probably had no earned income. And then move money timely into the regular IRA, at least based on the proposed regs. So we have a few things in here. One of the key issues in the regs is establish a concept they had in the notice that talks about the growth period. And we talk mechanics during the growth period, right? So the growth period runs from the account's establishment until December 31st of the calendar year the beneficiary turns 17. Now, like I said, all through that year, January 1st, most Trump accounts will exit their growth period before the child turns 18, right? The growth period is that period of time because we're looking at how old will they be at December 31st. That's going to be the key issue here. During the growth period, the statutory constraints regarding contributions, investments, and early distributions completely supersede all of the traditional IRA rules. However, on January 1st of that year, where the beneficiary is going to turn 18 during the year, the account automatically defaults back to standard Section 408 standard IRA rules. Technically, it's still a Trump account, right? We're going to get into that issue. It's going to stay as a Trump account, but now it's what you might well call the IRA, parenthesis, formerly Trump account, which will be different if you roll it into a regular IRA, which you can do. Then that'll just be an IRA account will no longer have the Trump account history. And that mainly becomes important for recovery of basis, as the notice made clear, right? So one of the things we need to do is strictly implement tracking of our client's beneficiary's birth date so we know, when that thing's changing, and warn your clients. The year in which that child turns 18, things change. And you're probably going to have to warn them of that as they're entering that year. You can't wait till you're preparing the return for that year because, it no longer works like the Trump. It's working differently. So you need that also because it opens up opportunities. You obviously can move funds into a lot broader array of investments once you have hit the IRA date, right? When we turn this thing into no longer the narrow focus of the Trump account rules, but into this former Trump account, but now can operate under the IRA rules, right? And also, we don't want to trigger prohibited transactions or improper contributions after that transition happens, because we have to understand, you got to switch your mindset. We're switching over to traditional IRA rules as of that January 1st, with one key caveat on distributions, but all kinds of things. So what about beneficiary eligibility and election procedures? So moving on to eligibility, the beneficiary must be under age 18 by the end of the calendar year the election is made. So if your child is turning 18 in 26, no election can be made in 26 to establish a Trump account. You're too late, right? We're kind of there. They didn't have it there. Treasury regulations explicitly adopted the birthday rule under Section 1.530A-1B5. But one of the key issues that's relevant is the child must have valid Social Security number issued prior to the date the election is made. You cannot retroactively fix that. So you got to have a valid social before you can make this election. If the child doesn't have a valid Social Security number, not going to be an issue. The election is made on new Form 4547, the Trump account elections, right? And it's independent of Form 1040, although it can be submitted with a Form 1040. It's one of those odd things. You can file a 4547 by itself. Now, the IRS discourages you doing a paper one by itself, or actually a paper one with a 1040 either. They don't like paper. What they want you to do is go onto their website where you will electronically be able to file the 4547. But they will accept paper if you have no other way. We can get that done. And as I say, if it goes with the 1040, that's great. You'll find that your tax software this year allows you to do that. But it's treated as if it's a separate filing for all those purposes. Now, there is a strict priority ordering rule in the regulation as to who can make this election. Right? Number one, if there has been a legal guardian appointed, that is the party that must make the election for the child, not the parents, right? If, however, there is no legal guardian, then a parent. Now, basic math here tells you, basic biology tells us that normally there are two parents, right? That's how, unless we're cloning the kids. So with two parents, there are two people who could establish an account. Keep that in mind because we can't have two accounts. That's going to make it really fun in certain divorce situations, but we'll leave that alone for now. Just keep that in mind. If no parent, all the parents have all passed away, then we look for an adult sibling, if such a person exists. So let's say, we have 4 kids in the family, and the kids are, 30, 25, 21, and 15. The 15-year-old can have a Trump account set up if both parents have passed away, and no legal guardian has been appointed for the 15-year-old. Then any one of the 3 elder kids, the 21-year-old, 25-year-old, 30-year-old, they could establish the Trump account on behalf of the 15-year-old. Okay. Finally, if none of those, there are no adult siblings, no parents died, right? There's no legal guardian, then the grandparents have a right to set this up. Be careful because you're going to have clients who think they can just set these up for their grandchildren. They can't. You've got to have the right person be the party setting it up, and they will be the one who essentially is in control of the account. So if you have clients with messy divorces or fractured family dynamics, you got to advise them we need coordination on this. Whether or not you want to talk to your ex, if you both have a kid between you, you and your ex are going to have to understand what's going on here because you can't both set one up. Okay? And basically, the first one to get the application in wins. That's the way it goes. And if a lower priority family member beats them to the punch, it's a headache because IRS isn't going to know, that basically if let's say, an adult sibling files it for their brother or sister, and mom and dad don't know that happened. The IRS doesn't know really that mom and dad aren't alive, at least not when processing this. They certainly don't know if a legal guardian's been appointed, right? So there's issues there. So what the regulation does, it does have a safe harbor that does treat the account as validly established to protect the child's tax benefits, but it will take control back to the authorized party, right? The higher priority family member could take control in that case. Now, let's talk about some administrative rules and some actions you might want to consider taking. Because a minor lacks the ability to direct investments or execute rollovers, the Treasury requires this responsible party to be recognized and determine who it is. Under the proposed reg, section 1.153 cap A-1D, the default responsible party is simply the authorized individuals originally elected to open the account. We also have an administrative relief provision. Any entity already approved as a non-bank IRA trustee as of December 31st, 2025, gets automatic approval to handle Trump accounts. Basically, if you're eligible to handle IRA accounts, you can be a Trump account custodian. You got to qualify, you got to meet with the rules, right, and do it properly, but you can do those. So it means that, the Vanguards, the Fidelities, etc. of this world will be able to set up Trump accounts and invite you to put your money, roll your money into there. Note, we don't yet know for sure, and these regs do not really tell us how the IRS is going to choose where the initial account goes. But I would note there is nothing on the 4547 that says, put this money in the account established at this particular custodian. I suspect what's going to happen is there will be a single custodian awarded the initial Trump account, contract. And if you don't want that custodian, what you're going to have to do is after the money arrives in the account for the kid, you're going to need to then move, basically roll the balance over. Now, how that's going to work if, you just establish the account, but your client, the child doesn't qualify. They weren't born in 25. They were born in 22. And they don't qualify for Michael Dell's money or anybody else's money because we have a few of these programs, which will be loads of fun to deal with to figure out who all is putting money in under what conditions. Let's assume they qualify for none of them. It's not clear how you're going to get away from that initial account. It may very well be you got to put the first deposit in that account. Then you could immediately roll that into the one you want to use. We'll have to see how they handle that or if they give us something in the proposed regs to make it easier. In any event, it's what we got, right? Now, these effective dates for proposed regulations will apply to taxable years beginning on or after January 1st, 26. They want them to apply this year, which means, obviously, the goal would be to get these final regs out before the end of December. And it probably wouldn't hurt us if they got them out before July 4th. We'll see if they make that. So right now, what you want to start doing is scan your clients, and see, do they have eligible dependents? And make sure that we understand, do you have eligible dependents? Do you understand about the Trump accounts? And if somebody has a child born in 25 or 26 or is expecting a child in 26, then you need to probably have the Trump account pilot program discussion. We'll talk about pilot programs here in just a second. So for those of you watching on the screens, whatever screen you're watching, TV, computer, whatever, take a look at the right side of this infographic we've got up here on the screen. This maps out the technical workflow that we just covered basically in this case, right? How it goes. So basically on the left side, I should say, of this, under section eligibility and establishment, you can see how this progresses chronologically. You got to have the child social security number account set up as soon as they confirm the eligibility child security number. We have to identify the authorized individual that can make the election and get that election made that way. And then we also have to, establish a responsible party who manages the funds. And again, we expect more guidance in this area over time. And this ties directly back to strict ordering and administrative mechanics that we just talked about in that background. On the right side, it contains the specialized growth period rules. Now, some things there we didn't cover in detail. We cap fees on the investment account. There's a limited number, right? It's got to be broad U.S. equity indices, and distributions basically can't be made until the child has turned 18 or the child dies. If the child dies, remember, under the Trump account rules, that thing is distributed effectively the instant the child dies, and either will be distributed to the beneficiaries established for the account or the child's estate. That's kind of how it goes, right? And that lockdown of distribution is meant to, essentially lock down those distributions to protect the child's interest. So they essentially get an IRA that enters adulthood at that point. We're going to be doing this. So it's a quick summary to grasp how this works. If you download the slides that we have on the website, currentprotaxdevelopments.com, and our video update link at the top, if you go and get the slides from there, you will find this particular part is a standalone slide. So you can, if you want to print that, hand that out to clients, do it on a color printer so it looks nice, whatever, fine. You can go ahead and do that. Next up is the pilot program under IRC section 6434. And this is the Trump account pilot program proposed regs, regulation 117-00225, issued on March the 6th of 2026. And it's going to take a look at Internal Revenue Code section 6434, added by the One Big Beautiful Bill Act, right? This authorized Treasury to make a one-time $1,000 contribution to eligible children's Trump accounts. Now, the key issue here, what are the structural mechanics of how the IRS is legally authorized to drop this money into a private account without triggering a constructive receipt or calendar year timing issues is going to be interesting. Got to understand technical plumbing, and we need to understand one key issue that's not yet resolved about not this, but when we go with normal funding for a Trump account, which currently, as the ICPA keeps complaining, we have no guidance. It would appear that this is not a present interest gift and would automatically trigger a 709, which we generally consider to be not necessarily what you'd probably want. Okay, let's talk about the deemed payment and the special taxable years. This is the mechanics of how this program works, right? To bypass the normal calendar year restrictions and get this $1,000 into accounts immediately, the Treasury invented a novel tax administration concept, which is called the special taxable year, because mechanically the code says this is a $1,000 payment refunded on the refunded on a return for that child. So how are we going to handle that? So the child is treated as making a $1,000 payment against income tax. Under the proposed Reg 301.6434-1B6, the moment the Treasury Secretary processes the election, a special taxable year instantly opens, the money drops in, it closes. Okay? That's how it works. It carries zero tax liability and is completely divorced from the electing adult's normal tax period. Because liability is zero, the $1,000 deemed payment instantly becomes an overpayment, right? Ladies and gentlemen, you have a refund, right? Which the Treasury then directly refunds into the child's Trump account. Remember, where it cannot leave until they turn 18 or they die. We have that. The regulations explicitly state this is not considered a claim for credit or for refund. So what that means is the funding mechanism is effectively instantaneous upon processing without having to wait until they file their annual 1040s in April. It will simply be funded. Once we get past, remember, we still got to wait for the July 4th date before anything goes in any of these accounts. But once we get there, in theory, your client would file the Trump account form during the year, the 4547, file it when the child's born. They have the social. Once they've got that, they file the 4547, and the account will be immediately funded. So I guess good news for us is we won't really have to, be the party primarily having to file these forms every year in the tax returns and having to find them. But it probably means we need to follow up, because I guarantee you there will be clients who, no matter how long this goes on, will never have heard of this, and we'll have to remind them, no, there's $1,000 and you can go get it. They have all of those who want the $1,000 that don't qualify, but that's a whole nother discussion for another day. So what about the eligibility rules and the strict offset protections contained in the code for 6434? Definition of an eligible child is extremely tight here. The child must be born between January 1st of 2025 and December 31st, 2028. They must be a United States citizen, and they must possess a valid Social Security number before the election date. So because the most significant thing to worry about is we have the offset protection, which is important. So if you have clients outstanding tax liabilities, back child support, or other federal debts subject to the Treasury offset program under Section 6402, you can reassure them that their child's Trump account $1,000 won't get grabbed to pay those other liabilities, right? Under Section 6434F, this overpayment, the $1,000, is completely exempt from offset or reduction. This is simply a mechanical mechanism Congress set up to dump the money in. It is a tax refund in name only. It is a tax refund, so procedurally, Treasury can set it up that way through the system, but nobody can grab that refund, right? It's not there. The IRS cannot seize it to satisfy parents' back taxes, unpaid child support, or anything else of that sort. It goes there because it is the child's, right? Not the parents. Of course, we weren't terribly concerned about the child having an outstanding tax liability, but you probably were concerned about the parents. Different issue. Now, let's talk about the anticipation standard and the timing rules. So you look up there, if you look on the video, this slide is going to cover a practical administrative hurdle the Treasury had to clear. How do you fund the account immediately if you don't yet know if the child qualifies as dependent year in? Guys, that's supposed to be the person filing and doing this stuff. How do we do it? Well, they solved this a forward-looking relationship test under proposed reg 301.6434-1B1I. Because only basically the person who claims the child is going to be able to ask for the $1,000. The electing adult has to legitimately anticipate the child will be their Section 152C qualifying child for that year. The good faith anticipation protects the election even if circumstances change by December 31st. For instance, your client expects to have custody most nights of the year. However, they don't, and therefore custody switches to the other parent. As long as your client can show that when they applied for the $1,000 for the child, that they reasonably anticipated having most of the nights, then we should be fine. It should work without a problem, right? Your major warning is simple, though, in this case. The election window closes strictly on December 31st, the year the child turns 17. And the regulations explicitly state that the Section 9100 relief is for a late election is completely unavailable. Now, as I said, that's pretty far out there, but I guarantee you somebody's going to run into this at some point. So keep that in the back of your mind for way in the future. When the first of these children hit age 17, right? So they're born in 25, right? So they're going to hit 17 in 2042. Yeah, I think I got that right. So 2042, that'll be the year, right? That they turn 17. On December 31st of 2032, you will have the first loss of 6434 options if they weren't initially claimed. So interesting rule there, right? If they miss the deadline, the $1,000 is gone forever. Of course, if they waited that long, they've also lost all the growth on the $1,000. That's not going to get replaced, even if they could replace the $1,000. So yeah, kid, mom and dad fouled up, didn't ask for the money. Tough luck. That's basically how that one's going to go. Okay. Let's talk about the filing mechanics and things that you need to take action on, right? Procedurally, this program operates on a ruthless first-to-file basis. Under proposed reg 301.6434-1D, Only the first process election per child triggers a contribution. Any subsequent elections are completely ignored. For us who are in practice, this creates an urgent action item for clients undergoing separation or divorce. You must coordinate this immediately so a non-custodial parent doesn't erroneously rush to submit Form 4547 first and lock out the custodial parent, right? That's going to cause so many problems. We're not going to start thinking about all the issues that creates, right? So advise all expectant clients in the 2025 to 2028 window, right? During years 2025's expecting child window is kind of closed by now. We had the child in 25, we didn't. But those expecting in 26 and all the way through the end of 28, which is going to create that whole bit about a child needs to be born by the end of December. Yeah, you don't want to be on the paper. They still do that in papers these days. We saw papers is probably the question. But they used to always like to publish, I know here in Phoenix, a story about the first child born in every year, right? The one they have right after midnight, the earliest birth certificate that was issued. So the earliest child born in Phoenix in whatever year. You don't want to be that person in 29 unless they extend the program. We'll just phrase it like that. Okay. So in essence, remind the parents about the fact that, we need to go through, get the Social Security number. Normally, you process that when the child's born and, submit that form. Understand that form needs to be submitted. They can do so online. It should be at www.trumpaccounts.gov is where you're going to find it currently. So yes, the parents just need to understand, go there once you've got the child's Social Security number, go there, apply for the account, and get your $1,000. Not as big a rush right now, but once we get to July date and the accounts start being funded, then I think, your client's going to want to just understand how to do that. So if you have any clients that are expecting a child in 26, you might just say, well, here's something to consider, when your child's born, you can do the 4547. You'll go online. If you want to get it done quickest, go online and give them, child's name, the information. You can show them the 4547 because it will show them the kind of things they're going to ask you. And then ask for the $1,000. I can't really file that one for you. I don't think there'll be any way they're going to grant us as paid preparers the ability to file that for somebody mid-year. They want to wait until the return next year, then we can do it. But that means you're going to lose out on growth. So bottom line, smartest thing to do is to file it as soon as possible. Because the sooner it's in there, the sooner it starts earning. That's basically how this works. So we have our next infographic for those of you watching here on the video, right? Let's examine this one now. We got this nice little line here of how things work, right? What we're going to do is it's a complex number of hurdles involved. If you look at phase 1, it directly reinforces what we've covered regarding the absolute necessity for obtaining Social Security number before the election is made. We need that number. So get the number, right? Take care of it. Then you can make the election in phase 2. And over in phase 3, you'll see the visual representation of that special taxable year, the magic tax return, right? And the explicit shield against child support, federal debts, and all those other items are discussed there, right? We've got that background. Then we take a look at the one-shot opportunity rule, right? This is a visual manifestation of the strict first-to-file rule we just warned you about, right? And this gets you to the background. After that, we move on to, the account creation and funding, as we discussed before. Because again, you can still put money in. Remember, we've got the $5,000 per year contributions that are allowed. We have and up to $2,500 of that $5,000 could come from an employer plan if you have an employer that's funding them for people. And how that grows over time with restrictions on investment, right? How the growth period ends when, as soon as we get to the first day, right? We get to that date. And essentially when it then kind of, converts to an IRA and the absolute lock on this account until the child turns 18. The child, the first day money come out of that account, the authorized party to pull it out is the child. So for those of you that worry about this has no what I refer to as Portia protection. The client wants to take that money you build up in that account. and use it to buy a car, right? Preferably a bright red Porsche. They can do it. If there's enough in there, they can pull that out. So probably not going to be the $1,000, but if there's more going in besides 1,000, which you might decide to do, then there might be enough in there to buy the Porsche. So keep that in mind. Okay, next up, we're going to go to essentially court case. And this is a case involving a micro-captive scrutiny and how that was formalized, how the IRS formalized it, and the challenge by the company that initially was successful in challenging the whole issue of using notices to add things to the listed transaction list. In essence, now tried to challenge the regulation that was issued. The case is CIC Services, LLC versus Internal Revenue Service. This is case number 3:25CV00146. The case was heard in the Eastern District of Tennessee, U.S. District Court, and the opinion was issued on March the 5th of 2026. Let's talk about the background of what went on before, right? You have to go look back at the prior litigation that involved those 2016-66. Now, at that point, your client might have breathed a sigh of relief in 2022 when the district court vacated that notice because the IRS failed to follow the Administrative Procedures Act's notice and consent requirement. At that time, the court also found the IRS's administrative record lacked the relevant data to support designating micro-captives as transactions of interest. But what happened at this point was the IRS didn't give up. Instead, they engaged in formal rulemaking, and after issuing proposed regulations, taking comments, and issued a final rule on July 14, 2025, where they responded to the comments, and they effectively adopted something very close to what they had before. Now, again, CIC Services is now coming back to court. They're seeking a permanent injunction against this 2025 final rule under the Administrative Procedures Act, which leads to the decision that we're looking at today. And in the interim, we also had Loper Bright come out of the Supreme Court. So CIC is going to try that route as well to challenge these regs. So let's talk about the 2025 final rule objective factors, right? And under the Technical Court 2025 final rule, it establishes a strict set of objective factors that designate a Section 831B captive, the micro captives basically come under there, as a listed transaction. You have to evaluate your client's captives against 3 specific tests to see if they fall in the listed transaction category. First is loss ratio factor, right? Which figures if insured losses and administrative expenses are less than 30% of the premiums earned minus policyholder dividends. So there's your first. Are losses low? And low is objectively measured as that 30%, of the total premiums after reducing any dividends that were paid out to the policyholders, right? Next is the financing factor, which targets arrangements that funnel the earned premiums back to policyholders or related entities in non-taxable transactions. So essentially, generally loaning it back out is usually the structure. And finally, there's a 20% relationship test that limits this reporting trigger to captors where at least 20% of the voting power or assets is owned by the insured or related person. If your client hits the trifecta here, they're now caught in the listed transaction reporting net for this transaction. Again, remember, as the party who is, let's say our clients who have implemented the micro captive transaction, that means they've got to file the 8886, I hope I got the form number right, reporting participation in listed transaction for every year it has any effect on the reported tax number. Anything that has an effect on the tax return. It means every year it's around. And this also goes back retroactively if they participated in it at the time it's put on the listed list. So this was then back in January of 25 when these regs became final. You had a limited period of time to go back and file these disclosures for all the prior years that you were involved in this transaction. So yeah, this is why. So we have these 3 tests. Now, obviously, CIC is involved in marketing these. This is not a selling point for marketing that you have to do this. In fact, it tends to scare clients off. So CIC obviously would prefer not to have to file, the clients have to file these things and not having to maintain the promoter list that otherwise they're going to have to maintain. Let's take a look at the court's finding. Did the IRS have statutory authority to do what they did? And a major argument made by CIC was that the IRS exceeded its statutory authority by imposing unauthorized requirements to obtain 831B tax benefits. And that's how they phrased it. They said you couldn't get the 831B benefits, because of these restrictions. You had to file this extra form. You had to do all these extra things, right? But the district court rejected the argument. The court pointed out, correctly, honestly, there's no question, that a captive does not automatically lose its 831B benefits simply because the IRS deems it a illicit transaction or transaction of interest. Instead, under Internal Revenue Code Sections 6011 and 6707A, Congress explicitly mandated the IRS to collect information on these transactions. And reality is, even if those information forms aren't filed, if this truly will pass muster as these types of transactions, then you still got that protection. You got a huge problem with failing to file required information returns. That's a different and very expensive problem. But you didn't lose the benefit. But so the court said, no, it didn't do this, right? The final rule merely creates disclosure requirements. It doesn't alter the substantive tax law regarding how taxes are assessed, right? And the IRS was complete within its delegated authority to issue these regulations. So they're able to do that. Don't tell me they exceeded their authority by doing this. Now, I understand CIC is talking here about literally, we can't sell these anymore. Maybe can't is a little too strong, but it's going to be difficult because clients know they're going to basically have volunteered, they're in the list. And as I said, that's not a good selling point. We're just going to say it. So next up, they went after where we've seen a lot more success in our APA challenges, where now CIC is going to try to apply the arbitrary and capricious standard, right? So did the final rule violate the Administrative Procedures Act arbitrary and capricious standard to see if the IRS examined relevant data? And the court said the IRS did it differently this time. In stark contrast to the 2022 case where the IRS's record was essentially empty, the court found the 2026 administrative record to be incredibly robust. The IRS relied heavily on its recent string of tax court victories, cases you may remember like Abrahami, Sisg, whatever. All these people have weird names, I've noticed, right? And Kaler. Kaler was probably the simplest one to pronounce. To justify these captive arrangements are potentially used for tax avoidance. The taxpayer argued the objective metrics were overly broad. The court applied precedent to rule that just because a regulation might be over or under inclusive, that does not automatically render it arbitrary and capricious. Arbitrary and capricious is a relatively high standard to clear, right? It suggests they had no real evidence to go on. The fact they might be overinterpreting it is a different problem. It's not going to make it arbitrary and capricious. So, of course, they're not now going to throw the regular out under the APA's arbitrary and capricious standard. So what was the conclusion of the court? Judicial conclusion, and what's our issues for compliance, right? So to wrap this up, the court rejected the taxpayer's claim that the final rule was just a pretext to eliminate the 831B deduction, noting that the internal IRS skepticism doesn't prove pretext. The IRS didn't simply say, we believe that this could be used aggressively, so we're just going to put it in the reg. They have a right to believe. Everybody has a right to believe, whatever there. They look at it, they read it. They're allowed to think that. The question is, did they go find evidence, right, to back that up? And did they listen to proper comments, right? In this case, the court granted summary judgment to the government. The court concluded the IRS successfully cured both procedural and substantive defects of the original 2016 notices. Now, takeaway is pretty simple here. The stringent reporting mechanisms and material advised disclosure rules for the 831B captives are fully enforceable law, at least per this district court. CIC has got to appeal. If CIC wants to win at this point, they have to appeal, go up to the Court of Appeals, and I believe this one would be the Sixth Circuit. And then if they win, whether they win or lose there, I would expect the next, either the loser there to take it, try to get Supreme Court to hear it. So this isn't absolute, but it's not a good sign. We have a reg here, and so far the reg's not been invalidated. And if you want to say the reg's wrong, that's great, but you just darn well better be right. Because if you're not, the penalties here are really bad. We're going to say that. So the days of shielding the transactions from disclosure based on administrative procedural defects are over. And you got to ensure clients are rigorously complying to avoid the crippling penalties associated with listed transactions, unless the client literally wants to be the party to go to court, challenge these regulations, and win. Because they're not, as we talked about earlier, we talked about proposed regulations on IRS, actually final regulations, we're actually on the IRS, appeals process. Appeals is never going to rule. If you're claiming the regulation's invalid, you're not getting appeals to agree with you on that or concede that in any way, shape, or form, unless you can point to a court case that is held they were invalid, and there are no longer appeals options for the IRS coming off of that case. In this case, the only case we got said the reg's valid. So, yeah, your client wants to challenge this and not file the disclosure. Great. But assuming they get caught, because again, material advisor has the list, assuming they're called in, you better win that case. That's one of those things like where you better win. And they briefly considered Loper Bright and effectively said, nah, the Loper Bright didn't just invalidate every reg. That's kind of how this works. So again, our graphics, we got the graphics every week now. So this has been a lengthy legal battle over micro captives that we just kind of looked at here. If you look at the left side of the graphics, right, under the invalidated attempt, it visually tracks a discussion of the 2022 district court ruling. Illustrating how notice 2016-66 was struck down for procedural APA failures and deemed arbitrary due to a lack of supporting data in the administrative record. Then you follow the arrows over to the right side, where things don't go as well for the taxpayer. The current legal standard, which maps directly to 2026 court decision, we just reviewed. Notice how the visual, notice how the visual explicitly highlights the three objective factors that we just discussed, right? 20% relationship test, the financing factor, and the loss ratio. So you can use this to show clients that while they may have won a temporary reprieve back in 22, that reprieve right now, the only time we've tested these regs, because the regs were meant to overcome that case, the very court that ruled notice 2016-66 was invalid has now decided to rule that this one is valid. So, yeah, if you don't want to disclose now, you are really doing it at your own risk. Like I just tell them, you better darn well be right. And I've got some issues signing, which is another problem with no disclosure. That sort of thing, at least without an A275R. And A275R kind of probably defeats the whole purpose of not disclosing. So, yeah, we'll just go with that at this point. Okay, finally, we're going to take a look at Bipartisan Budget Act audits. Notice defects and statute of limitations. This is a case of Mammoth Cave Property LLC versus Commissioner. It's a published tax court decision, 166 TC number 4, issued by the court on March the 9th of this year. Right. So, as we know, the BBA, flipped my slide too early, right? The BBA's centralized partnership audit regime replaced TEFRA, right? The very, very last TEFRA cases are clearing out of the court now. And we got all BBA stuff. And this is one of the early BBA cases with a key issue to discuss. The IRS has been ramping up enforcement, particularly on syndicated conservation easements. You know that if you've been listening here for a while, because we've had a whole bunch of those cases, right, that we look at and have talked about. This case is relevant to the average firm because it deals with a scenario we see all the time. A change in designated partnership representative, administrative delays in processing an address change. We're going to look at what happens when the IRS messes up the mailing of audit notices and how that defects interacts with statute of limitations. Okay. So let's start with Mammoth Cave and look at the BBA framework and our background of this case. So let's take a look at the background of Mammoth Cave. Timeline is pretty important here. The partnership was audited for 2018 charitable contribution deduction. And remember, 2018 was our first BBA year, right? During the audit, the partnership properly filed forms to revoke its original partnership representative. Okay, during the audit, filed forms to revoke its original partnership representative, or PR, and appoint a new entity PR along with a new designated individual, or DI. Later, the new DI submitted an address change, but due to IRS processing backlogs, that address change sat in a pile of forms for months and wasn't actually processed until August of 2022. Because of the backlog, the IRS mailed the crucial Notice of Proposed Partnership Adjustment, the NOPPA, to the former representative at the old outdated address. But here's what's critical. They directed the notice to the attention of the current designated individual. They got the designated individual updated. They were missing a couple other things, but they sent it to the right person. It was to that person. Now, key question is, did that person get it? Okay. So now I'm going to look at these statutory notice standards under the Bipartisan Budget Act, right? From a technical perspective, we need to understand statutory notice standards. Under Internal Revenue Code Section 6231A, the IRS is required to issue 3 principal notices during a BBA audit. The Notice of Administrative Procedure, the NOPPA we just talked about, and then the final partnership adjustment. The code dictates these notices must be mailed to the partnership and the partnership representative. Under IRC Section 6223A, the partnership representative holds the sole authority to act on behalf of the partnership. But when an entity is the PR, Treasury Regulation Section 301-6223-1 steps in to specify that the designated individual is the sole individual through whom the PR will act. So even though the partnership representative is an entity, the individual is the person that has to take action. So the individual now becomes the key issue, the designated individual, right? The court had to decide if mailing the Notice of Proposed Partnership Adjustment to the correct designated individual, but the wrong partnership representative entity at the wrong address met the statutory standard. To do so, they went back to old TEFRA cases, right? Holding a notice simply needs to provide minimal notice to the taxpayer that adjustments have been determined. So, what about the standard limitation here? Why was the partnership fighting so hard over this defective notice? Well, simple reason. The statute of limitation under Section 6235 is what they're working with here. Under the general rule 6235A1, the IRS has a standard 3-year assessment window. However, there's an extension built into Section 6235A2. When a partnership requests to modify an imputed underpayment, the deadline to issue the final partnership adjustment, the FPA, is extended 270 days after the modification submission is complete. In this case, after receiving the defectively addressed notice of proposed partnership adjustment, the partnership's designated individual actually filed for an extension and submitted a modification request. This is going to get us to the no harm, no foul problem, as we'll note. The taxpayer's strategy in this case was to argue that the notice itself is invalid. They've read the tea leaves. They've seen what's happened to these conservation easement cases. This is a conservation easement case. Yeah, they want it thrown out of this technicality. They really want it thrown out in this technicality, right? Because if that notice proposed partnership agreement was invalid, it would mean it failed to properly trigger the extension of time 6235. So the later filed final partnership adjustment would have been issued too late, after the last date for the IRS to issue the notice, because they didn't have the extra 270 days they thought they had. So the real question here is this conservation easement going to win on a technicality? Because again, now they may still fight in court to try to win on the actual underlying case, but you might understand why if that was your issue right now, why you might want to be looking at trying to find another way to win this one out. So we got that going on. So what did the court hold on the defective notice, right? Again, the taxpayer is rolling the dice on a procedural argument because, we know how this looks otherwise. We don't want to go and fight the main part. If we can win on this, we don't worry about becoming the next case in a long line of tax court throws the book at, a conservation easement case. So we're good. Again, maybe they got the perfect case. Maybe they'll be just fine. In which case, then it would still make sense to go for this, because why pay all the money to pay all the experts to come and testify during your trial if you can just win on this? So again, doesn't mean it's all wrong, but I certainly would put it this way. It wouldn't surprise me that they were really thinking that this was now their best chance, right? So the taxpayer suggested that because the NOPPA was addressed to the former entity representative, an outdated address, it was completely invalid. And therefore, it failed to trigger the extended statute of limitations under 6235A2. Right? The tax court disagreed. The court focused on the fact that the IRS directed the notice to the attention of the current designated individual, Mr. Mills. Statutorily, he is the sole individual authorized to act on behalf of the partnership. Further, this is where the court really comes down on him. There was actual receipt. Because as an individual and the partnership's attorneys actually received the notice and actively engaged the IRS by filing for modification extensions, the taxpayer suffered absolutely no prejudice by the problems that there were in the notice of partnership, proposed partnership adjustment. They were not negatively impacted. And that means the NOPPA was valid. Therefore, the FPA was timely issued. Therefore, you're going to win this. You got to win on the underlying tax argument now. The administrative process went out. Right now, the key holding here is important for tax practices, especially in partnership areas under BBA. But actual receipt and subsequent taxpayer actions can confuse, and this has been true in other areas too. It tends to cure mailing defects. Yes, the IRS is deemed to have given it to you if they mail it to your last known address. But what if they foul up and they send it to the wrong address? As long as you got it, that's not going to make it an invalid notice, is what the courts have held generally, right? In essence, no harm, no foul. So because the NOPPA was deemed valid, the final partnership adjustment was timely, and the taxpayer must now essentially face or challenge the substantive adjustments in this case, right? So, in essence, an IRS typo is not a get-out-of-jail-free card. It is a get-out-of-jail-free card if your client didn't actually get the notice until after the end of the time period, or they got it so close to the end it prejudiced them. But if the taxpayer got it, and what the court points out here, not only did the taxpayer get the notice, they had time to request the extension, prepare the documents. It's like there was nothing that negatively impacted them by the fact that this thing got misaddressed, because they just continued on like normal. And only later did they come back with this argument that it was invalid. Now, I admit, had you started immediately arguing it's invalid, the IRS would have had time to correct it. So it's like, yeah, you have a little trouble. So this is one you look at later. But as I say, this is especially, this whole invalid notice works best when, in fact, the notice arrives after the date to take action, or so ridiculously close to the date to take action that, the taxpayer was disadvantaged. In this case, absolutely no evidence the taxpayer was disadvantaged. It appears Mr. Mills got it just as quickly as he would have had it been properly addressed in that case. Oh, and I should add, not helping matters was the fact the partnership itself and the organization that was now the new partnership representative, they kept using the old address. So for various filings with the service. So that also probably didn't help their case with the court. Minor detail. Okay. So now again, our last infographic of the date for those of you with the videos, right? We're going to look here at the complex Bipartisan Budget Act statutory framework and how the court's ultimate rationale that we talked about here over the last few slides work. On the left side, under primary legal authorities, you can see specific code sections we discussed. 6232.1's notice requirements, and 6223 defining the sole authority of the partnership representative, and the section 6235 limitation of extensions, or limitation extension, I should say. The center column is a comparison between the partnership's highly technical arguments, wrong name, wrong address, and the statutory conclusion of the court, the no harm, no foul rule, right? By the right side, reinforce our discussion from the immediately preceding slide, we were just on. Actual notice cures technical defects, and actions taken by a designated individual inherently signal the notice's validity. If they acted on a purely timely basis, the same way as if they'd received the notice, addressed correctly, then that's evidence there's no prejudice. This is the summary about why typos on those notices are not the perfect get out of jail free card. Yes, you note them, and that's why, you're probably going to immediately find, if you're talking about this, the first question that an advisor should pose to people when you see there were typos on it is, when did you get this? Because clients tend to sit on things sometimes to the last second. If you got this, 2 days after it was mailed, then we're probably going to lose this argument that the notice is invalid. However, if you got it, let's say 2 days before the 90 days was going to run out, then you probably got a much better chance of getting it invalidated, right? And then you're better off. Of course, the catch is at this point, you just got to kind of, work your way through that problem and see how things work. And generally, since we're talking about, in many cases, court litigation, and we are in this case talking about it, this is probably something where legal counsel needs to be involved. Again, remember, as a CPA or an EA, yes, you can represent clients in the U.S. tax court if you take the tax court exam. Most of you haven't. And you don't want to be, therefore, doing things that prejudice the case where another professional is going to have to pick it up in those venues and then discover that you fouled it up and lost everything way back because you didn't understand how it worked when it went up the line. If you're thinking about trying to argue that you've got an invalid notice, I would probably seek some legal counsel about what they might suggest to do about that, how to handle it. Because remember, quite often you're going to get a notice, and this notice might be misaddressed, etc. 90-day notice, but that 90-day notice may still be within the time frame, even if that wasn't valid. Right, we're past day 90. There still may be time the IRS could still correct the notice and get it out in time for good again. So that's why it becomes a real interesting issue. Do you have? I don't think the courts will say have an obligation to tell the service that they screwed it up, but you will eventually have to tell them because you're going to have to say why you don't owe the money. But yeah, it gets messy there. So in any event, this is, I say, no harm, no foul was the ultimate idea of the court, how to deal with this. So this wraps up our weekly look at the current federal tax developments. We have the new Trump account information, which is most of what we talked about this week, including the $1,000 companion pilot program. We talked about the micro captive regs, that were issued to take over for the notice that was thrown out. And the first court test with the court that threw out the notice says, okay, these are good. We accept them. So that's probably not good news for people who are in the micro captive area to see that too. Doesn't mean they're done, but it does mean that, a court that was, shall we say, sympathetic to your arguments previously didn't have sympathy after this point. So again, not those issues. And then we talk about the BBA audit standards, right? And notices when they're valid and when they're not. And when errors in IRS notice end up falling into the no harm, no foul, the actual notice got properly delivered. It doesn't matter. It was misaddressed because you weren't prejudiced. If you have any questions, you can reach out to me, edzolles@currentfortaxdevelopments.com. You also can find me on the Connect sites for Arizona Society of CPAs, New Jersey Society of CPAs, Idaho Society of CPAs, Minnesota Society of CPAs, Illinois Society of CPAs, and the Washington Society of CPAs. Otherwise, we will hopefully be seeing you back here next week. Oh yeah, don't forget, if you're listening to this on Monday, March 16th, yeah, today's the due date for all of your past due entities, so keep that in mind. We're there. But otherwise, hopefully we'll see you next week. Again, as we get closer to April 15th, there will probably come a week where I'm just going to have to kind of shut down and decide that we will catch up after April 15th. But we're not quite there yet, so we've got this published, and we will see you hopefully next week for more current federal tax developments.